The Retirement Cafe podcast, the mismanagement of asset protection trust schemes. Hello and welcome to another episode of the Retirement Cafe podcast with me, your host, Justin King. If you're thinking about your retirement or already retired, you're in the right place. My aim is to help you plan for and live a successful and meaningful retirement. Retirement is far more than just a financial event. It's a significant life event, a major transition, which will bring with it new challenges and opportunities. So each episode contains tips, information, and inspiration to help you feel more informed and confident about your retirement. I hope you enjoyed today's episode. Welcome to the Retirement Cafe podcast. This week, I want to talk to you about the FCA has issued about the mismanagement of asset protection trust schemes. Now, if you're not familiar with them, this is not the first time that these so-called asset protection trusts have been in the news, but this is the first time that the FCA has actually felt moved to issue a warning. The FCA says that they've seen cases of firms seriously mismanaging trusts with unsuitable investments made by trustees. And the FCA clearly believes that people are not sufficiently aware of what they're getting into when they sign up for one of these arrangements. So what are they? Well, these are the types of trusts where you transfer your assets, usually your home, but often other assets as well, into a trust during your lifetime. And the idea is you're going to protect your assets from creditors and maybe more importantly, the local authority for care fees. And you may believe the promoter's claims, i.e. the seller's claims that your assets are going to be also avoid inheritance tax. That is usually not true. The FCA are warning that where trustees involved are not sufficiently competent or not acting in your best interest, there is scope for your money to be misused. It is possible for trust assets to be inappropriately invested, including into high-risk illiquid assets. And in most cases, these investments are not suitable. When investments are made through a trust, there is also a risk that the usual consumer protections are lost. Often the firms that are kind of emphasizing the benefits of these trust arrangements, including, shielding that your assets from certain claims, costs, or fees, for example, in the event of divorce or probate. And they may also promote high rates of return on the assets or the investments held in the trust. In practice, such schemes often achieve very little by way of protection, but generate massive fees for the sellers of these schemes. And the fees I've seen prices in the region of £2,500 to £5,000. What the FCA recommends is the best way for you to protect yourself is to seek independent legal advice to ensure that the trust will actually work to deliver the intended protection of your assets. And get also independent financial advice to validate any proposed investment strategy before agreeing to put any money, property or assets into one of these trust schemes. The advice needs to be truly independent, and that means it should be from someone who's not connected to the person proposing to set up the trust for you. In addition, according to the FCA, an individual should read their trust agreement very carefully. Make sure it clearly sets out what the trustee is able to do with your assets. In particular, that the types of investments the trustee may make and the level of risk that might involve matches your preferences. If the agreement does not set out your investment preferences, then the default investment power will be in place. And this means that the trustee is permitted to invest your assets as they see fit, which could include investing in high-risk investments. You want to check if the firm is regulated by a member of a professional body such as STEP. STEP is the Society of Trust and Estate Practitioners. If so, they should be subject to some standards of conduct, unlike non-regulated trustees. Check out the FCA's Scam Smart and Invest Smart pages for more information on avoiding scams. Interestingly, currently STEP's carrying out research about will writers, estate planners and estate administrators, specifically asking their members for examples of when unqualified or incompetent advisors have taken advantage of their clients or let them down because of lack of specialist skills and knowledge. STEP aims to demonstrate the impact of unqualified, incompetent will writers and estate planners, and the importance of using a STEP practitioner. They say that they're going to use the results of this research to inform the policymakers of the issues and help the public understand the dangers of using unqualified or uncredited practitioners. This is possibly a response to the recent government announcement that the government, do not intend to review the provisions of the Legal Services Act in 2007, despite concerns about unqualified practitioners entering the legal services area. The Legal Services Act provided that it was an offence for a person to carry on a reserved legal activity unless they are entitled to do so. And reserved legal activities are specifically defined in paragraph 5. It kind of basically is about preparing any instrument relating to real or personal estate for the purpose of the law of England and Wales. Similar legislation appears in Scottish legislation. And this would include trust documents as well as, ancillary documentation such as deeds of appointments, assignment wills and other testamentary instruments. This doesn't include, powers of attorney. They're particularly excluded as there being a reserved legal activity. The main perceived problems are with the so-called will and estate planners who take advantage of the fact that will drafting is not a reserved activity. So such a firm may have a front, who officially provides the trust documents, but the advice that you're getting is given by someone who's not legally qualified. You don't want to ask them, are you legally qualified? Tell me your qualifications. We've seen some awful scenarios, and some practitioners complain that, that they can draft a trust in a will, they cannot legally provide a trustee, and should this be so? Well, the answer, frankly, should be that they should not be allowed to draft wills involving trusts at all. It's notable that Age UK describes these trusts as a worthless piece of paper. And in the past, the Consumers Association, which, that produced the Which magazine, described these trusts as something you definitely do not need. Despite the government's refusal to review the issue at the moment, it's hoped that more publicity and public education, prompted by the FCA and, of course, soon STEP, is going to lead to better understanding by consumers, i.e. you, and therefore you've less risk of vulnerable clients being missold these schemes. If you've been missold one of these schemes, or you're concerned about one of these schemes, what I suggest is that you take it along to a STEP practitioner. I'll put a link in the show notes so that you can find out where you can find a local STEP practitioner, and maybe along to a good qualified independent financial advisor who may be able to review it and give you some advice, or even refer you on to someone who can check out the validity of the trust and the suitability of it. I hope that's helpful and of use. Please let me know if you've got any thoughts or comments, or you've been missold one of these schemes, or you're unsure of what you've ended up buying. Thanks for listening. My name's Justin King. I'm a chartered and certified financial planner. My aim is to help you live a successful life. Obviously, please subscribe so you never miss an episode. And of course, for you YouTube watchers, please like the video so it really helps the channel. Thanks so much. Bye-bye.